Palmer, Dwayne.
Oh, Palmer. Palmer's that one. All right, so let's jump in. So, good morning, everyone. This is the Spalding County State Court. My name is Josh Thacker. I'm your judge, and this is the bonded arraignment calendar. I want to start out by saying here in the Spalding County State Court, we believe that each and every one of you, as you interact with this court, deserve the respect and dignity that you would wish for someone you care about. We'll extend that to each and every one of you as we interact with you all here today. Hey, please do not talk during court. So our goal is to handle your case efficiently and return you back to your lives as soon as we can. I will not have any patience with any disruptions because it makes everybody get out of here later. All right, I have one virtual person, a Sabrina Williams. So if you want to mark your calendars. Sabrina Williams, go ahead and grab a pen and a piece of paper or some way to write down the information that I'm going to give you. Wait for me to call your name. You will not be able to unmute yourself. I can see you trying to unmute yourself. I'm saying don't unmute yourself. I'll just come back to you. Okay, so cell phones. Everybody here right now, take out your phones from wherever you stashed them and turn them off. I was laughing with the early folks this morning who were here about 8:30 and telling them that everybody has pet peeves. Some people it's drivers in the left lane going too slow. I don't know. Me, it's cell phones ringing in the courtroom. I just am giving you fair warning that if your phone rings because you ignored me at this moment and you didn't turn your phone off and it rings, then I'm going to respond in a very pet peeve manner. So you have officially been warned that I will not respond in a rational and appropriate way to your phone disrupting my courtroom. And that's it. So please don't volunteer for that. This is the correct courtroom for you if you are arrested on a misdemeanor here in Spalding County. You received a letter in the mail instructing you to appear in the state court today. If what I'm saying sounds incorrect, then speak with the bailiffs. They will show me your paperwork. They will point you in the right direction. Today is what's called your arraignment day. I'm going to go over your rights with you, and I'm going to tell you what your options are, and then you or your attorney can tell me what to do with your case. Now, you may have a trial. There are two types of trials. There's a jury trial where 6 jurors issue the verdict from that box over there to your left. And then there's a bench trial, and that's where I issue the verdict with no jury present. You may have a conference with the solicitor's office if you wish. That's this group up here to your left if you're representing yourself. And if you don't have an attorney, you may ask me about getting an attorney, and I will direct you up here to the public defender's office, and they will give you instructions on how to apply with their office. All right, Miss Karen is here from our Veterans and Mental Health Court. So you'll also hear us call that our Accountability Court. So if you're a current member of our military or a military veteran, or you have a mental health diagnosis and you would like your case dismissed, then at the first break, you may speak with Ms. Karen and see if you are a candidate for our accountability court. If you miss a chance to talk to her, you can ask for a conference with the solicitor's office. They can help you figure out if you're a candidate. And then lastly, if you have an attorney, just simply speak with your attorneys. They're all very familiar with the program. Everybody's charges in this courtroom are misdemeanors. The average misdemeanor carries a maximum punishment of 12 months to serve in the Spalding County Jail and or a $1,000 fine. A few minor traffic charges like seatbelt have a lower maximum fine, and a few highly aggravated misdemeanors have up to a $5,000 maximum fine. All right, each of you have the right to a speedy and public jury trial, where 6 citizens of Spalding County decide guilt or innocence on your charges. You can also choose bench trial. That's where I decide guilt or innocence without a jury. You can waive your right to a trial and close your case with a plea. I have no preference. You must knowingly, voluntarily, and intelligently choose for yourself. Okay, I'm so sorry, I got to pick on somebody. Gentleman in the back, black shirt. Hey, you haven't looked up in the last couple slides. I'm sure you're listening intently, but when you don't look up at the PowerPoint, I worked really hard on this very boring PowerPoint. So if you will just watch the very boring PowerPoint with me, I would be very grateful. But I haven't seen you look at about the last 5 slides. And, you know, I worked very hard to make this the most boring and informative PowerPoint ever in the history of humankind. All right. You have the right to be presumed innocent. You have the right to force the state to prove your guilt beyond a reasonable doubt. You have the right to cross-examine the state's witnesses, to subpoena your own witnesses and evidence to court. You have the right to testify or not testify. You have the right not to incriminate yourself, and if you remain silent, your silence cannot be held against you. You have the right to have an attorney. You may hire your own attorney if you so choose. However, if you cannot afford an attorney, then you'll be given an opportunity today to speak with the public defender's office. and they will give you instructions on how. Is Ms. Porter here?
She'll be here, Judge.
Okay, so you'll be given an opportunity today here in the courtroom to apply with the Public Defender's Office before you leave. Now, this is your warning, and I'm amazed at how many people test me on this. If you do not apply with the Public Defender's Office ASAP, you will very likely hear me say at your next court date that you have waived the right to apply for their services. I'm amazed at how many people say no to the appointment today, come into the next court date, ask for continuance so they can apply with the Public Defender's Office, and I'll go ahead and tell you, my answer is probably going to be no. So if you want them, take action. All right, an attorney would help you understand our criminal justice system, would explain what the charges are and what the defenses are to those charges, would file motions on your behalf, engage in plea negotiations, subpoena witnesses and evidence for your defense, conduct a trial on your behalf and make objections, protect your record, appeal a conviction, and just otherwise work to protect you. All right, first offender and conditional discharge. I'm responsible for explaining these to you all, and these each allow you to enter a guilty plea without being convicted. However, you only get one of each for your entire life. Now, first offender is for everything but traffic-related charges, so no DUIs, and conditional discharge is for drug-related offenses only. All right, no-look contender-rated traffic charges. We call this a no-look plea for short. Lets you enter a guilty plea without admitting guilt on traffic charges, no DUIs. You get one no-load every 5 years, and that's measured from the incident date to incident date, ticket date to ticket date. No-load will usually prevent points. It will usually save your license. It will not help you much if you're under 21. All right, if you're here today and you're not a U.S. citizen, then you need to know that any conviction will very likely have a negative impact on your immigration status. All right, family violence charges. If you are here today and you are charged with family violence charges, which is in the title of your charge, and you are convicted of that family violence charge, then you need to know that you'll lose your Georgia weapons carry permit. Federal law will step in and say that you may never again possess a firearm or ammunition. All right, it is my job to explain this weird old law called habeas corpus. You've heard the words before, and it does a lot of things in a lot of different situations. But for our purposes here in this courtroom at this moment, here's how it works. If you're convicted of these charges, doesn't matter how, you may sue Spalding County civilly over in Superior Court to challenge your conviction. All traffic charges have a 6-month window to use your habeas rights. Everything else has a 12-month window to use your habeas rights. All right, you may conference today with the solicitor's office. If you're here and you're represented by an attorney, your attorney will very likely announce conference on your behalf. That's what you brought him here to do, speak on your behalf. The solicitor's office, again, that's this group up here to your left, they represent the state of Georgia. They are not your attorney. If you reach an agreement with the solicitor's office, great, you can resolve your case today. If you do not reach an agreement, you waive nothing. You just simply tell them that you wish to have a trial, or tell the bailiffs. We'll happily have you sign your paperwork and move you in that direction. All right, if you receive probation today, you'll be supervised by the Spalding County Sentence Enforcement. There will be a one-time $25 intake fee per case. 100% of all fines may be worked off with community service work at a rate of $10 per hour. Additionally, there's a $50 per month supervision fee each month until you complete your probation. The $50 supervision fee is mandatory, but it can be waived after a separate hearing before me. All right, so for those of you that wish to move over to a trial calendar, you need to plan ahead. All the trials will go on the same 2-week trial calendar. In week 1, there will be calendar called, and you'll be brought in to announce on your case. And then we'll all skip a week in the middle while everybody prepares for trial. And then in week 2, jury trials and bench trials will begin promptly at 9 a.m. And you will appear each and every day until your case is resolved. We will run 2 or 3 courtrooms in week 2, and we will reach your case for trial. All right. Do you want to help your friends and family? Because we're still a small enough community where everybody knows somebody who knows everybody. So if you recognize the name of someone who is not here, who has failed to appear, then you need to call them, tell them to get down here ASAP, and you'll very likely, and you will save them a great deal of future trouble. This is a very effective tool. Please, if you know a name, call them. All right, so I'm about to call the calendar. When you hear your name called, stand up if you're able. If you're not able, then just wave your hand up high and get my attention. If you have an attorney, remain silent and let your attorney announce for you. So many of you here are represented by the Public Defender's Office. Let them announce for you. That's what you brought them here to do. If you do not have an attorney though, then you're gonna announce for yourself. So for those of you representing yourself, you will announce, you'll stand up and you'll say jury trial, or bench trial, or conference, or attorney. I'll give you instructions from there and then we'll keep going. All right, let's jump in. All right, Waderius Andrews. Andrews.
Stabilized for bond forfeiture and bench warrant.
Granted. Mark Ballou.
Conference.
Conference, thank you. Wyson Bogan.
That's for bond forfeiture and bench warrant.
Granted. Joseph Brown. Joseph Brown.
That's for bond forfeiture and bench warrant.
Granted. Carrie Brownlee. Carrie Brownlee.
That's for bond forfeiture and bench warrant.
Granted. Austin Cassidy. Conference, thank you. Bobby Collier. Conference, thank you, Mr. Collier. Blake Collins.
Conference.
All right, thank you. All right, that's page one. Amari Davis.
Conference.
Conference, thank you. All right, Mr. Malloy's client, Mr. Evans, is in jail. We'll see him this afternoon.
Yes, sir.
Melissa Fennell, or Fennell?
Conference.
How do you say your last name?
Fennell.
Fennell, all right, thank you. Kamal Foster? Foster?
That's for bond forfeiture and bench warrant.
Granted. All right, Mr. Gata filed a waiver on Galindo. Jury trial. Joshua Glasser, or Glazer? Glaser?
That's for bond forfeiture and bench warrant.
Granted. Katrina Hicks? Hicks?
That's for bond forfeiture and bench warrant.
Granted. Pedro Ho? Yuen-Fei Ho?
That's for bond forfeiture and bench warrant.
Granted. Devin Jenkins?
Conference, Your Honor.
All right, thank you. Jukes, conference, got it. Nevaeh Jones,
Conference.
and how do you say your first name?
Nevaeh.
Nevaeh, okay, names are important. Thank you. All right, I show Alicia Kelly as jail, but not public defender.
Correct, Your Honor.
Okay. Currently self-represented defendant. Okay, Renee Landers? Landers?
That's for bond forfeiture and bench warrant.
Granted. Tamarius Lewis? Lewis?
Well, that's for bond forfeiture and bench warrant.
Granted.
There's a second case on that. It's not on the calendar. It's
All right.
21 TK 2559.
21 TK, 21
25. 2559.
2559. All right, so I'm gonna go ahead and mark this one as a do not reset. And that'll, since there's two cases, and then we'll let the other one catch up. So 22 SR 1549, I'll mark as do not reset. All right, Caleb Moss. Moss,
That's for bond forfeiture and bench warrant.
granted. Kendall Nobles. All right, thank you. Darian Parker. Parker,
That's for bond forfeiture and bench warrant.
granted.
There'll be a write-in on this page.
All right,
It's Brianna Morgan. It's a DUI. It's Mr. Dutton's case.
okay.
She's pled into, well, she's already entered into accountability court, so she's walking in this morning to enter her half plea, I guess is what we're calling
Yeah,
it.
if you find a more appropriate term, we can do that, but half plea seems to work. So, if you all want to grab your client, go fill out the right sheet, I'll take it before I leave the bench. So,
I gotta get the plea sheet written up.
okay. Is that your only case, Mr. Dutton?
Yes, Your Honor, and we'll let you know as soon as we got all that paperwork signed.
What was the first name?
Brianna,
Do y'all have a case number?
I don't have it.
That's okay.
Mr. Dutton.
You can get it from there. That's not a hurry. All right, Travis Patterson, conference, thank you. Kelly Henson? Henson?
That's for for bond forfeiture and bench warrant.
Granted. Kayla Pollock. Pollock.
That's for bond forfeiture and bench warrant.
Granted. Randy Rehall.
Yes, sir.
Conference.
All right, and Rehall's the right way to say it?
Yes, sir.
All right, like I said, names are important. So, conference. Joey Rosado? Rosado?
That's for bond forfeiture and bench warrant.
Granted. Travis Smith? Smith?
That's for bond forfeiture and bench warrant.
Granted. Back to you, Mr. Malloy. Lisa Spears? Spears? No?
That's for bond forfeiture and bench warrant.
Granted.
That's a DUI with a 91 mile an hour speeding when that's not be lifted.
Yeah. That's fine. All right, 2 cases. Jarmel Stanley? Stanley? There's the plate. Oh, okay. The case numbers are awfully close, so I just got confused. All right, there's 2 cases.
Well, that's for bond forfeiture and bench warrant on both.
Screen. Tiny Starks? Starks? Conference, thank you.
You're welcome.
Frederick Stubbs?
Here. Here.
All right, do you want to talk to the Public Defender's Office?
No, sir.
Are you waiving the right to apply with the Public Defender's Office?
Yes, sir.
Okay, then I'm gonna put down that you're waiving the right to apply with the Public Defender's Office. If you will step out into the hallway, you may certainly hire your own attorney if you wish, but either way, you'll either represent yourself or get a private attorney, is that correct?
Yes, sir.
Okay, if you'll wait in the hallway for the bailiffs, he just needs to sign the reset notice. Clifton Taylor? Clifton Taylor?
That's for bond forfeiture and bench warrant.
Granted. Brianda Walker? Conference, thank you. Jarvis, looks like 2 cases, 3 cases. Jarvis Watson? Watson?
That's for bond forfeiture and bench warrant on all 3.
Granted. Okay, Brianna Williams. Brianna Williams?
That's for bond forfeiture and bench warrant.
Granted. All right, Sabrina Williams is virtual. I'm gonna come back to her in just a minute. Kenneth Ray. Kenneth Ray.
That's for bond forfeiture and bench warrant.
And then I go right in. Gordon Lynn. What's that name?
Conference.
Okay. It says from August 21.
So he's accountability court.
Okay.
I think we already had him. He may just need to enter his plea this morning, but we'll speak with him.
Okay. Is that correct? You're entering our accountability court program?
I'm already in.
You're already in it. Okay. Then
Yeah.
that's neat. Then you're gonna have an easy day. So, all right. That sounds
Yeah, he was the one, Judge. He was supposed to be here on Monday, but he had some, he had to be in court in Atlanta somewhere. So we just switched this one out rather than asking Atlanta to continue it.
Yeah, no, this is a great solution to set. Okay, all right, then let me see if I can get Miss Williams unmuted without too much. All right, Miss Williams, I sent you an unmute request. Can you approve that?
Yeah.
Okay, that's a no, but I'll circle back to her. Y'all can't see it, but she's struggling. She's really trying. Oh, there we go. I hear you. Can you hear me?
Yes, sir.
Okay. Ms. Williams, will you please give us a good phone number in case we need to reach out to you?
Okay, I gotta go through my phone, but will I click y'all off?
So, no, I tell you what, I'm gonna go ahead and do some other stuff while you're doing that. And then I'll come back to you in just about 3 to 5 minutes, okay?
Okay,
All right, thank you.
but,
Mr. Shepard. All right, Ms. Shepard, floor is yours.
All right, good morning, all. I'm Patrick Shepard. I'm the solicitor. That means that I'm the prosecutor. I'll be the ones that have the conferences this morning, except for who are represented by an attorney. If you're represented by an attorney, you need to follow your attorney's instructions for the rest of the morning. I'll speak with them. They'll relay a plea offer to you. So just follow whatever they tell you to do the rest of the morning. If you do not have an attorney, you've asked for a conference. What's going to happen is in a few minutes, Ms. Sherry Middleton here with a black shirt on, and Ms. Denise Fletcher over there against the wall with a white shirt on. We'll start calling names. When your name is called, you're going to follow either Ms. Middleton or Ms. Fletcher out these double doors over here to my right, your left, follow them down the hallway, there's a little area outside of my office with several chairs, have a seat in one of those chairs, and I will call you back one at a time for your conference. When you're done with your conference, you're gonna come back down the same hallway, come through the same set of double doors, quietly have a seat here in the courtroom, either enter your plea or get instructions for your trial date. When you come back into the courtroom, make sure that you do use the single door, the double doors here, not the single door over there next to Deputy Corley. If you come through that single door, you'll disrupt the court, make the judge unhappy, not a good way to spend your Wednesday morning. Obviously, there's a lot of y'all, there's only one of me, but I do this pretty much every day. I know what I'm doing, I move quick. I'll have everybody out here at a decent time today. All right, thank you.
All right, Mr. Malloy?
I don't have an announcement this morning, Judge.
Okay, and I realized I forgot to make an announcement. Is there anyone here whose name was not called? I think there was somebody who tried to report virtually Monday who's here today. Okay, what was your name?
Virginia Jones.
All right, and that was not your fault, Ms. Jones, that I was unable to run the virtual system Monday. And so, let me find your case. There, well,
Page 8.
page 8, there it is. Okay, so everybody on page 8, Virginia Jones, I'm lifting her warrant. She had reported virtually. And of course, I hadn't had a chance to I wasn't here to run the system, so it's what it is. Ms. Jones, what would you like to do with your case?
Conference.
Okay. Perfect. And everybody please mark it that there never was a warrant. That was not my fault. So, okay, Ms. Jones, sit tight. Luckily for you, we have a slightly smaller calendar. We should be able to get to you this morning. Okay. Then what I'm going to do is this. I'm going to, at this moment, give you all, okay, so here's what's about to happen. Statistically, I'm about to say, hey, you can step to the restroom and get back to your seats, but one of you is going to choose to go home. I don't know why. Every single court day, one of you decides that you're just done and you're just going to go home. What I have to do with that is I issue a warrant, Piper goes and picks you up, put handcuffs on you, takes you to the jail, and then you wait at the jail till I come see you. I don't know how that keeps happening, but it does. Every single court day. So, because here's the instructions, you ready? They're super simple. Hey, we're all human, we've all had coffee, step to the restroom, get back to your seats. Like, it's that simple. Step to the restroom, get back to your seats. But statistically, one of you will volunteer to go to jail. Don't be that one person this morning, okay? So, here's the instructions. Step to the restroom, get back to your seats. Because, like I said, every single day, I have to issue a warrant for somebody who, they just go home, I guess. I'm not really sure. So, with that said, it is 9:28. I'm going to step off the bench until 10. I'm going to try to talk to Ms. Williams before I step off the bench. But if y'all if the public defender's office needs to go get reset, and if y'all want to go ahead and call your first round, that's fine. And then I'll talk to Ms. Williams, and then I'll step off the bench.
Can I get a signature?
Okay. Oh, yeah, Piper was telling me that he died. Is that his?
Mhm.
Yeah.
Allard, yeah, he was on a motorcycle.
Doors, and we'll meet you in the hallway. Gordon Lynn, Mark Ballou, Austin Cassidy, Bobby Collier, Blake Collins, Amiria Davis, Melissa Fennell, Nevaeh Jones, and Kendall Nobles.
Patrick's already aware of it. He said,
Devin G.
he don't know how it made it on the calendar, but he was already familiar with it.
But, yeah, it was on the jail calendar.
All right, Ms. Williams, I sent you an unmute request. All right, everybody, let's come back to order real quick. Ms. Williams, did you have a chance to get a phone number for me?
Yes, sir, I do.
All right, will you give it to me, please?
Yes, sir. 404-645-0853. That's Cassandra. And then the second number will be 678-588-2389. That's Brenda.
All right, you gave me 404-645-0856.
Yes, sir.
And then you gave me 678-588-2385.
2389.
8, 9. Well, that's why I read them back.
Yes, sir.
2, 3, 8, 9. And so
Yes, sir.
either of those numbers will get to you.
Yes, sir.
All right. What would you like to do with your 2 cases?
I would like to put them all together. I want to do a jury trial, plead not guilty. I just need, information from the public defender to get all the
Yes.
paperwork up from, the incidents that had happened.
Okay. So,
I do,
so in just a moment, Ms. Williams, I'm gonna cut you off because you gave me information I need to pass back to you. So in just a moment, I'm gonna give you your new court dates. So be ready to write those down when I give them to you. And then as far as the public defender's office goes, if you will go to spaldingcounty.com, go to the state
hold on a
court.
second. Spalding County.
.com.
That county, is it spelled out all the way?
Yes, I get that question a lot. The answer is yes.
Okay,
So spaldingcounty.com.
okay,
And then if you'll go to the state court page,
okay,
you will see the contact information for the public defender's office.
okay.
It is your responsibility to take action ASAP.
Okay, how long do I have?
Well, I'm about to set your case for January, so I'd say you got about, and they need plenty of time and lead time, so I'd say you got about a week or two to get in contact with them and get lined up.
You said I got a week to do what now?
To get your application in with the public defender's office.
Okay, all right, gotcha.
All right, your next court date on both cases is as follows. Your calendar call is January 9th, 2024 at 9 a.m.
For both of them?
Yes.
Okay.
Where are you virtual today? Do you live out of state or something?
Yes, sir. I've been living out of Oklahoma this whole time. I just had a few incidents with my family. Like my grandson getting shot at the car wash. With him making the news and defects coming in, taking all of my kids. Also, my mom, where I was living at the address where my first 7 tickets were. I lived there for 3 months until I got my paperwork from Oklahoma to move there. So I left the house with my mom, my siblings,
Okay.
and they all caught coronavirus.
So hold on. So listen up, because I'm about to change the directions just a little bit. So on January 9th of 2024, you do not have to physically come to this court. You can report virtually in the same way you're reporting right now without permission. I've already written it on here, okay?
Okay.
You usually have to get permission each time to report virtually, and I'm letting you skip that step. But it's a double-edged sword because I'm not allowed to do virtual trials, which means that if you want trials on both of your cases, you need to plan on being here in person in the courtroom the entire week, January 22nd.
I'm sorry, sir. That last part where you said I have to come there and apply to make all 7 charges go together, both of them.
Well, you asked for jury trials, and I'm telling you your jury trial dates, and I'm telling you that you have to be here in the courtroom for your jury trial dates.
Okay, and which are those again? You said January the 9th. I'm sorry, I didn't hear you.
Yeah, January 9th, you can be virtual. The week of January 22nd, you have to be here in the courtroom the whole week. Or until we close your case, whichever happens first.
Okay, so you're saying January the 9th is my virtual case for?
That's correct, at 9 a.m.
At 9, right? But that's for the first 7 charges?
For all your charges.
Okay, for all of them. So we're doing another virtual, okay. And then you said January the 22nd would be for the jury trial.
The week of January 22nd. The week of January 22nd.
So, okay. Oh, it's gonna last a week? Okay.
Or until we close your case, whichever happens first.
And you said I would have to be here, right? Be there, I'm sorry.
In person, in the courtroom. I'm not allowed to do virtual trials. I would if I could, but I'm not allowed to.
So what day would I have to leave from over here? You said it's the 22nd. What is that week? I don't have a calendar. I'm sorry.
I'm not giving you your travel schedule. I'm just telling you that I expect you to be sitting in my courtroom at 9 a.m. on Monday, January 22nd. Where you are at 8:59, I don't care, but at 9:01, you better be in my courtroom.
And
So
that's
you-
January the 22nd. I'm confused. Hold on 1 second. Let me write this down the correct way, sir. You was breaking up too at the end, so I'm just trying to
Okay.
get an understanding.
All right, I'm gonna do the whole thing. Don't interrupt me, okay? Just gonna go through the whole thing so the record's very clear what I'm telling you, okay? Are you ready?
I got you.
Okay.
Yes.
On January 9th of 2024 at 9 a.m., you have my permission to report virtually, exactly the way you're reporting now, to this courtroom for your calendar call. After that, if you do not resolve your cases, which are 22 SR 1537 and 22 SR 1538, you must report to this courtroom in person, in that seat out there, on January 22nd, 2024 at 9 a.m. sharp. That is Monday. And you must be prepared to stay the week or until we resolve your case, whichever happens first.
Okay.
That's in person.
Okay.
If you wish to apply with the Public Defender's Office, go to spaldingcounty.com, go to the state court page, and there's a link to the Public Defender's Office website and their phone number. And it's your responsibility to take action and to get that application in ASAP.
Yes, sir, I understand.
I will not be granting a continuance in January if you do not take prompt action to get your Public Defender's Office taken care of.
I'll start on it next week. I got you. I heard you very clear, sir.
All right. Do you understand that this is the only notice you will receive of these court dates? Nothing's coming in the mail. It's what you and I are doing right now that is your notice.
Yes, sir. I got it jotted down.
Do you understand that if you miss any of these court dates, I will issue a warrant for your arrest?
January the 9th and January 22nd. Yes, sir. I'm gonna attend. I got
Okay.
you. I heard you.
All right. And it's just my job to say awkward things like this out loud. Hey, and you understand it's the week of January 22nd.
Yes, to be prepared to stay all week. Yes.
Okay, perfect. All right, that's it. That's all the information I need to give you. We will see you in January. Again, take action on the Public Defender's Office so that I don't have to tell you that you need to represent yourself, okay?
Okay. Thank you so much, sir.
All right, thank you.
Yes, sir.
All right, that's my virtual person. All right, so didn't quite make it off the bench 10. I'm gonna go ahead, I'm gonna move her off. Just 1 second. All right, what's your name, Mr. Charles?
So we have worked out the terms of the plea should she not be able to make it through the accountability court, Your Honor. That said, it's our expectation that she will be able to make it through. To that note, does this need to be turned on?
So, yeah, just turn it on, please.
Sorry, I didn't know. To that end, Your Honor, there are some concerns with her ability to complete this. Not in her ability to do what's asked, but her ability to keep and maintain a job during the accountability court. I think we're gonna need the court's help making sure that happens. She's working on and already has some of the certifications for EMT and is looking forward to moving into a law enforcement capacity as well. That said, obviously the way their shifts work are very specific, and you don't get to say, hey, I need Thursdays and these days off to come to the court. That said, I think with the court's help, in specifically speaking to those employers, that I think there'll be a magical way to work those out. So we will need the court's help in doing that.
Well, and I'm very confident that we'll figure something out, because we very much want you to want to be engaged. We want you to, feel supported. And frankly, we want you to successfully complete it. So there will be expectations of you, Ms. Morgan, but at the same time, I'm confident we will figure something out for you. So, all right, well, let's do the preliminaries. If you'll raise your right hand for me, ma'am. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, take your hand down. Grab that microphone, lean into it, and state your full name for me.
Brianna Morgan.
All right. Ms. Morgan, your case is a walk-in. Your case number is 23SR0807. What this is it's got a more formal name, but we call this our accountability court half a plea. So what we're about to do is we're going to go through a plea just like normal. But instead of sentencing you, I'm going to set the sentence. I'm not going to sentence you. What instead I'll be doing is simply having you waive your right to withdraw the plea, subject to completing the accountability court program. Is that acceptable to you?
It is.
All right, so let's jump in. So your attorney, Mr. Dutton, has passed to me this attorney and defendant plea rights waiver. Do you recognize this document that I'm holding up?
I do.
Are these your initials next to each of the lines on page 1?
Yes, it is.
Page 2?
Yes.
And is this your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, I did.
And having an opportunity to ask your attorney any questions you have about it?
I did.
And because you understood everything that's on it?
Yes.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes.
Are you satisfied with the job Mr. Dutton has done on your behalf?
I am.
Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial, and you're giving up all your rights, including this key grouping of rights here that I'm pointing at on page 1.
Yes.
Is that what you want to do with your case?
Yes, I did.
All right, so do you have any questions for me about the facts or anything else? About your rights or anything else before I pivot to the facts with your attorney?
No, I don't.
All right, Mr. Dutton, do you stipulate that there's a sufficient factual basis on this case for me to accept this DUI plea from December 29th of 2022 here in Spalding County?
We do so stipulate, Your Honor.
Do you wish to enter a guilty plea to that DUI charge, Ms. Morgan?
Yes.
All right, Mr. Dutton, back to you. Do you stipulate that there's a stop sign violation, a factual basis for the stop sign violation?
Yes, Your Honor.
All right.
There was a single car wreck involved in this as well.
Oh, okay. And Ms. Morgan, do you wish to enter a guilty plea to the stop sign violation?
Yes.
Okay. So I'm going to find with Mr. Dutton's stipulations as to the factual basis on counts 1 and 2, combined with Ms. Morgan's request to enter guilty pleas to counts 1 and 2, that there's enough for me to take these pleas. I'm going to find that Ms. Morgan is knowingly, voluntarily, and intelligently waiving her rights in entering this plea. I've reviewed the recommendation, and if it becomes necessary for me to sentence, I will follow the sentence exactly as it's been negotiated. Mr. Dutton, I appreciate your concern about that, and Ms. Morgan, I hope I've addressed that concern to say that, when you're in part of the program, that it's a relationship like anything else. And so if you're working hard and you're doing everything you can do to make it work, and you're communicating with Ms. Heffern and Ms. Karen and the team that's in charge of helping you get sober and stable and well, then they're gonna work with you. But if you're not communicating and you're not checking in and you're not showing up, well, then they're gonna bring in the guardrails. So I'm confident that you're gonna be just fine. It's my job to say awkward things like that out loud. But I'm just telling you that, as long as you communicate well with them, you will very likely get exactly the support you need to make it work. Does that make sense?
It does.
Okay. Mr. Dutton, do you wish to put anything else on the record before I wrap this up?
Yes, Your Honor, very briefly. When her assessment came back, she had an alcohol severity rating of 6 out of 9. This is what they consider a considerable problem. The people that are in her position, when they go into the accountability court, especially in phase 1, tend to have several bumps in the road that they have to go over. I would anticipate her situation being no different than all those. That said, I think that once we can get through these bumps, these initial issues, I think she'll be able to accomplish this court just fine to be able to make it through with flying colors.
Right. And I believe you as well. And Ms. Morgan, Mr. Dutton has hit the nail on the head that you need to remember is that the transition into accountability court always has some bumps at the beginning. And just keep your head down, just keep pushing your way through it and you'll get there, okay? All right, so Ms. Morgan, do you have any questions for me before I finalize this and close it out and let you go start accountability court?
No, I don't.
All right, so Ms. Morgan, the terms of this agreement are that if I need to sentence, I will sentence it exactly according to these terms. In the meantime, though, do you waive the right to withdraw this plea unless and until you complete the accountability court program?
Yes.
Mr. Dutton, do you stipulate so on behalf of your client that you will not seek to withdraw this plea without her completing the accountability court program?
We so stipulate here.
All right. Well, given that stipulation and given Ms. Morgan's agreement, and for record purposes, I also have the accountability court contract up here, which she has already initialed and signed. Judge Essery has also signed. I'm going to go ahead and peel the original of the sentencing sheet off, and I'm going to attach it to the back of the contract. If you'll give those to Mr. Dutton and his clients, y'all get to keep those. That way there's no question whatsoever as to if it becomes a sentencing issue, what the sentence will be, because you all have copies. And then this original, of course, is attached to the contract. And if it ever becomes necessary, I will literally print this off the contract. With that said, Ms. Morgan, I'm going to ask Ms. Kathy Leach, court reporter, to please create a transcript of this so that there's no confusion as to what the terms were and what was said and what we're doing. Anything else, Mr. Dutton, before I adjourn?
No, other than the fact that she has actually already begun and been accepted into the program. I believe that happened 2 weeks ago, and we're off to a good start so far. Obviously, there are bumps in the road when someone's transitioning into a program, but she has already begun and is so far successful in the program.
Okay. Ms. Morgan, do you have any questions for me about anything before you and I part ways?
No, I don't.
Okay. Well, good luck to you, ma'am. And I look forward to seeing you. Well, I guess you'll be here tomorrow afternoon for accountability court. Is that correct?
Yes.
All right. Well, then I'll see you tomorrow afternoon.
Mhm.
So, all right. Thank you very much. You're both pretty good.
Thank you, Your Honor.
All right. That just goes down there. If I'm not mistaken, that puts our accountability court, Mr. Dutton, at 30. Bobby Collier. If you'll come up to the podium. All right, Mr. Collier, if you will, please raise your right hand for me. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, take your hand out and state your full name for me.
Bobby Jerome Collier.
All right, and Mr. Collier, you are here on 22 SR 1611, and according to my calendar and my memory, you were on time for court today. Is that correct?
Yes, sir.
Mr. Collier, did you hear the rights that are read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes.
Did you understand those rights?
Yes.
Any questions I can answer for you about those rights?
No.
Mr. Collier, you have passed up to me this self-represented defendant plea rights waiver. Do you recognize this document that I'm holding up?
Yes.
Do you recognize it as the written version of those rights I read out earlier?
Yes.
Are these your initials next to each of the lines on page 1,
Yes, sir.
as well as page 2?
Yes.
And is this your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it?
Yes.
And because you understood everything that's on it?
Yes.
Did you see on here where it says that you have the right to have an attorney represent you?
Yes.
And you're here representing yourself? Is that what you want to do? All right. And do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial. This case will be closed. Is that what you want to do?
Yes, sir.
All right. Mr. Collier, do you have any other questions for me about the self-represented defendant plea rights waiver or anything else before I pivot to the facts of your case?
No.
All right. Mr. Collier, you are charged in 22 SR 1611 with one count, a reduced charge of disorderly conduct from August 22nd of 2020. And that you did here in Spalding County act in a disorderly manner in the presence of Renea Bentley in a manner that threatened the immediate breach of the peace, which is a reduced version of the charge you came in on. Did you do that?
Yes.
All right, I'm gonna find, with your admission of guilt as to the reduced charge of disorderly conduct, that there's enough for me to take your plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I'm gonna follow the recommendation. Do you have any questions about anything before I sentence?
No.
All right, you ready?
Yes.
Okay. Bobby Collier, 22 SR 1611 from August 22nd of 2020, count 1, disorderly conduct. We won't find you guilty. It's 12 months probation, $300 is your fine. You may work off your fine with community service work. There'll be show your valid license for probation. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 one-time intake fee. And this case will close the moment you've satisfied your obligations to the court. You have 30 days from today if you wish to appeal this decision, and you have 12 months from today if you want to use your habeas rights. Do you remember me talking about habeas earlier?
I don't understand.
Well, most people don't. It's okay. So let me explain again. So it's this weird old law where you sue Spalding County civilly over in Superior Court to challenge this conviction. Again, weird old law, but what I need you to understand more than anything else is you have 12 months from today before those rights expire. So I don't need you necessarily to know how to do it. I just need you to know when it goes away for you. Do you understand that you have 12 months from today to explore those rights?
Even though if I pay it off?
No, that's only if you want to. So if you wake up tomorrow morning and you think that your rights were violated in some way by this court or in this plea, then that's one way you can go about challenging the conviction. You don't have to, it's if you choose to.
Mm-hmm.
Does that make sense?
I think I understand.
So like I said, it's weird.
If I don't pay it off, it'll still be on me. If I pay it off, I'll be off of it. That's the only question.
That's correct.
Okay.
So, okay, perfect. Well, then that's both our topics. Good luck to you. Thank you, Mr. Carter.
Go. Thank you.
All right, so. All right, if you'll please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down, state your full name for me.
Melissa Nicole Fennell.
All right, Ms. Fennell, you are here today on 22 SR 1616, and according to my calendar, you are on time for court, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Ms. Fennell, you have passed up to me this self-represented defendant plea rights waiver. Do you recognize this document that I'm holding up?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
And is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Any questions I can answer for you about anything on this document?
No, sir.
Ms. Fennell, did you understand that you have the right to have an attorney represent you?
Yes, sir.
And you're here today representing yourself?
Yes, sir.
Is that what you want to do?
Yes, sir.
Do you understand that you have the right to a jury trial, including this grouping of close rights here in the middle of page 1 that I'm pointing at?
Yes, sir.
And that by entering this plea, you're giving up those rights and there will be no trial. Is that what you want to do?
Yes, sir.
Do you have any questions for me about anything we've covered so far or anything you want to ask before I pivot to the facts of your case?
No, sir.
All right, you are charged with disorderly conduct, and that in 22 SR 1616, back on July 15th of 2022, that you committed the offense of disorderly conduct, and that you did act in a disorderly manner here in Spalding County in the presence of Harry Fennell, in a manner that threatened the immediate breach of the peace. Did you do that?
Yes, sir.
I'm gonna find with your admission of guilt as to the reduced charge of disorderly conduct that there's enough for me to take the plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I've reviewed the recommendation and I will follow it. Do you have any questions for me about anything before I sentence?
No, sir.
All right, you ready for me to sentence?
Yes, sir.
All right, let me just squeeze that. The pause you caught for me is just a procedural question, which was, your name comes up in my system a couple of different ways. And so I just wanted to make certain I got it right. Were you ever known as Reeves?
Yes, sir.
All right, is that, I guess maybe a married name you no longer use?
It's my maiden name.
Maiden
I just
name.
haven't changed it back.
Okay, and so having you as Melissa and Nicole, no, that's correct.
Yes, sir.
And it's 2 N's, 2 L's?
Yes, sir.
Okay, got it. All right, just clean that up. All right, then, you ready for me to sentence?
Yes, sir.
All right, so again, I'm gonna find that you are knowingly, voluntarily, and intelligently waiving your rights to enter the plea. I've reviewed the recommendation and I'll follow it. The sentence of the court is as follows. On 22 SR 1616 from July 15th of 2022, count 1 disorderly conduct, I'm gonna find you guilty. It's 12 months probation, $590 is your fine. Show your valid driver's license to probation, no alcohol, illegal drugs, or hemp products. Fourth Amendment waiver, $50 per month supervision fee, a one-time $25 intake fee, 20 hours of community service work, no violent contact with Harry Fennell, and your case will close the moment 6 months have passed, no violations have occurred, and all conditions have been met. You have 30 days from today if you wish to appeal this decision, and you have 12 months from today if you wish to use your habeas rights. Do you remember me talking about habeas earlier?
Yes, sir.
And you remember reading about them on the back of the right sheet right there?
Yes, sir.
All right, do you have any questions for me about anything before you and I part ways?
No, sir.
Okay, then I'm gonna pass you off to Mr. Taylor. He's gonna walk you out those double doors and have you go meet with the probation.
All right, thank you.
All right, Mr. Lynn, if you'll please raise your right hand for me. You solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
Gordon Lynn.
All right, Mr. Lynn, I believe you were on Monday's calendar, but we asked you to come in today, is that correct?
Yes, sir.
So, there we are. So you were on page 8 of Monday's calendar, on 22 SR 1525. And it's my understanding you've already entered our accountability court and are currently a participant, is that correct?
Yes, sir.
So here's what we're gonna do. The way we handle this is, you and I are about to do what we just have been calling a half a plea. And so I'm gonna go through a plea just like normal, except when I get to the part where I would say, and the sentence of the court is, we're gonna stop there, and I'm not gonna sentence you. And then you're gonna waive the right to withdraw your plea unless and until you complete the accountability court program. And then you'll get to withdraw it and it'll get dismissed, okay?
Okay, thank you.
Is that fair?
Yes, sir.
All right, well, let's do that then. Mr. Lynn, according to my calendar, you were on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
I'm holding up this self-represented defendant plea rights waiver. Do you recognize this document I'm holding up?
Yes, sir.
Do you recognize, I'm sorry, are these your initials next to each of the lines on page 1,
Yes, sir.
page 2,
Yes, sir.
and is this your signature?
Yes, sir.
Did you sign and initial this document after having all of the time that you needed to review it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Are there any questions I can answer for you about anything on this document?
No, sir.
Do you understand that you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself, is that correct?
Yes, sir.
Is that what you want to do, is represent yourself?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, this case will be closed? Is that what you want to do?
Yes, sir.
All right, Mr. Lynn, any other questions for me about anything before I pivot to the facts of your case?
No, sir.
Okay, give me just a second, I forgot to pull your file up over here. All right, you're charged with one count of criminal trespass, and that you did here in Spalding County on November 7th of 2020. Unlawfully enter upon the premises of Deborah Lynn after receiving notice that your entry was forbidden. Did you do that?
Yes, sir.
All right, I'm gonna find with your admission of guilt, there's enough for me to take your plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I reviewed the recommendation, and should it become necessary for me to sentence on this case, I will follow the recommendation exactly as it's been negotiated. Now, at this point, I would normally sentence, but what we're gonna do is a couple of things differently. This is an accountability court plea, which means that I need to ask you, are you waiving the right to withdraw this plea unless and until you complete our accountability court program?
Yes, sir.
Do you understand that if you fail to complete our accountability court program, we'll have a hearing with you and me where I'll decide whether or not to remove you from the program. And if I remove you from the program, then I will sentence you and I will follow these terms exactly as they've been negotiated.
Yes, sir.
Okay. And you agree to all of those?
Yes, sir.
Okay. Then that's what I'm going to do. I'm going to note for the record that you have waived the right to withdraw this plea. I'm going to note for the record that, oh, he does need to sign this. So he needs to sign right here before we finish it, so I can acknowledge that it's signed. And I'm gonna ask Miss Kathy to do a transcript.
Yes, sir.
Okay, and this is your signature here on this signature page?
Yes, sir.
All right, so I'm not gonna sign it. What I'm gonna do is, I'm gonna peel the original off, and I'm going to have that be attached to the contract. I'm gonna pass you back the yellow and pink copies, those are yours to keep. Have you all, let's go off record. Have you all already received, Erica, the contract?
Let me look.
If not, I think what I'm supposed to do with this is to give this packet back to the solicitor's office and they'll get it.
What's up?
Okay. All right, well, let's get back on record then. All right, Ms. Lynn, do you have any questions for me before you and I part ways?
No, sir.
So I will see you tomorrow afternoon at Accountability Court?
Yes, sir.
Great. So I'm gonna send your paperwork back to Miss Leslie. She'll attach it to the contract and we'll see you tomorrow afternoon.
Okay, thank you.
Thank you. Okay, that's good. That means it needs to go with. So. All right, if you'll please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your name.
Travis Patterson.
Mr. Patterson, you were here on 22 SR 1612, and according to my calendar, you were on time for court today. Is that correct?
Yes, sir.
Did you hear the rights and read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
All right, so I'm holding up this self-represented defendant plea rights waiver. Do you recognize this document I'm holding up?
Yes, sir.
Are those your initials next to each of the lines on page 1,
Yes, sir.
page 2,
Yes, sir.
and is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Mr. Patterson, you have the right to have an attorney represent you, and you're here representing yourself. Is that correct?
Yes, sir.
Is that what you want to do?
Yes, sir.
You understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, there will be no trial, and this case will be closed. Is that what you want to do?
Yes, sir.
All right, Mr. Patterson, do you have any questions for me about anything before I pivot to the facts of your case?
No, sir.
All right, well, Mr. Patterson, you are charged with 1 count of no insurance, which is count 2. You're asking me for a no-low plea, is that correct?
That is correct, Your Honor.
And have you used a no-low plea on a no insurance in the last 5 years?
Yes, sir.
All right, then this is what you want me to use your no-low on, is this no insurance charge from July 18th of 2022?
Correct.
Okay. Then I'm going to find that your request for a no-low is proper, and I'm going to grant it. I'm going to find that you knowingly, voluntarily, and intelligently waive your rights during this plea. I reviewed the recommendation, and I'll follow it. Any questions about anything before I sentence?
No, sir.
Okay, you ready? All right, Travis Patterson, 22 SR 1612, from July 18th of 2022. Count 2, no insurance. I'm gonna grant you no low. It's 12 months probation, $445 is your fine. You may work off your fine with community service work. Count 1 will be dismissed. Show your valid license to probation. No alcohol, illegal drugs, or hemp products. You'll be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 one-time intake fee. And your case will close the moment you've satisfied your obligations to the court. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Do you remember me talking about habeas earlier?
Yes, sir.
And do you remember reading it on the back of the right sheet right there?
Yes, sir.
Okay. Do you have any questions for me about anything before you and I part ways?
No, sir.
Okay, then I'm going to pass you off to Mr. Taylor. He's going to have you go meet with probation, and I'm going to wish you the best of luck.
Yes, sir.
All right, thank you. You may go out those doors. or affirm the testimony that's given this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down and state your full name for me.
Freedom Walker.
All right, and Ms. Walker, you're here on 22 SR 1535. And Ms. Walker, you're here today because you're, I'm so sorry. You were on time for court today, is that correct?
Yes, sir.
And did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
I'm holding up the written version of those rights, which is this self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Are these your initials next to each of the lines on page 1,
Yes, sir.
page 2,
Yes, sir.
and is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Do you understand that you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself?
Yes, sir.
Is that what you want to do?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
All right, so, will you spell your middle name for me? I have it spelled 2 different ways.
It's SHATADEIA.
Okay, thank you. Got it. All right, so, do you have any other questions for me about any of the rights or anything else that you can think of before I pivot to the facts of your case?
No, sir.
Ms. Walker, you're charged with 1 count of false name, and that you did here in Spalding County, back on November 2nd of 2020 with a false name, to law enforcement, with the intent to mislead them. Did you do that?
Yes, sir.
All right, so I do this in every plea that I take with a false name, false date of birth. Will you please slowly and clearly give me your first name, middle name, last name, and will you spell your first name for me?
Freedom Shatavia Walker. FRIEONDA.
Okay. And then what is your correct date of birth?
December 13, 1989.
Great. And I just wanted to make certain that our system had you spelled correctly and had everything in here correctly. All right, I'm going to find that with your, I won't pass that to Mike, so I don't mess it up. All right, I'm going to find with your admission of guilt, there's enough for me to take your plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights. I'll review the recommendation and I'll follow it. Any questions before sentence?
No, sir.
You ready for me to sentence?
Yes, sir.
Okay. So, Ms. Walker, on 22 SR 1535 from November 2nd of 2020, count 1 false name, I'm going to find you guilty. It's 12 months probation, $445 is your fine. Counts 2 and 3 will be dismissed. You need to obtain a Georgia driver's license, no alcohol, illegal drugs, or hemp products. You'll be tested for those with a 4th Amendment waiver, $50 a month supervision fee, $25 one-time intake fee. And the moment you've satisfied your obligations to the court, your case will close. You have 30 days from today. If you wish to appeal this decision, you have